Alright, this is video log 2, going over the illegal kidnapping of my girlfriend's daughter and the blatant comments by CPS against the Constitution. I believe this is part 3. What I was just going over is the paperwork that I drew up for the attorney for our defense, all the work that I did looking up the laws to show that the state could not take our child no matter how much they wanted. So far I went over the evidence supporting our case, so I went over the laws, and I state that, I have the actual, in here I have the laws and the appeal decisions, and I have them numbered here. As you can see, that would be number 23, and I have them numbered in here so that, as they're reading this, they can look and go, okay, there's the law right there. So I have examples of everything, all my exhibits in here. Now, the next thing I was going to get into is the other evidence that's supporting our case. Alright, there is, and this is talking about not my biological daughter, but my girlfriend's daughter. There is no evidence of abuse, sexual or other, in regards to I. A taped interview with I conducted by Abigail Wilson of the DHS to determine if Mr. Dyer has ever sexually abused her produced no evidence of abuse. On the contrary, I specifically named Mr. Dyer when asked who protect her. Mr. Dyer has been a part of day-to-day life for 4 years, and it is destructive to her well-being to remove him. There is such lack of evidence that DHS has failed in their attempt to gather enough evidence to remove I from the home, and has had to make threats to take I on the grounds of refusing to do a voluntary service plan. That's that 2-year service plan I was talking about in the last video. Alright, so that they were using that alone, me refusing to do that 2-year course and admitting to be a child molester, to have grounds to take her from the home. Even going so far as to say that all court involvement will be dropped if Charles and Amanda would just agree to that plan. And I have that as Exhibit 14, and that's the transcript of the DHS worker that I read off in the last one. Alright, the DA claims that I is not receiving proper care and guardianship, and requests that the court order her deprived and remove her from our home on 2 grounds. The first being that the mother, Amanda, is failing to protect the child from threat of harm by continuing her to allow the child to associate with Charles Dyer, even after learning Mr. Dyer's propensity to sexually abuse children. So they have already proved to Amanda beyond a shadow of a doubt, without the legal system, that I raped my daughter on January 2nd, even though Amanda was with me all day January 2nd, and I was never alone with my daughter. But they say it's so, so it must be. The almighty government has spoken. The fact is, actually, the state has failed to provide evidence to Mrs. Monsalve that Mr. Dyer has a propensity to sexually abuse children. They have only told her hearsay about comments that Mr. Dyer's daughter has made. She has seen DNA evidence that refutes the charges against him, as well as doctor reports that do not support that he molested his daughter. She also knows that Mrs. Dyer had her brother make false allegations on Mr. Dyer in 2009. The DHS worker has even stated that I is not in any kind of imminent threat. Once again, put as Exhibit 12, part of the transcript from DHS. And has never been abused by Mr. Dyer. The statement that Mr. Dyer has a propensity to sexually abuse children with only hearsay as evidence and no criminal conviction violates Mr. Dyer's rights to be presumed innocent until proven guilty, and shows complete prejudice against Mr. Dyer by the prosecution. Allowing a child to associate with someone is not a crime without a protective order. Now, the second ground was that the mother and Charles Dyer have failed to cooperate with a voluntary plan to ensure the safety of the child. First of all, the mother did not fail to cooperate. I failed to cooperate because I will not admit to a crime that I did not commit. This ground alone is not enough to take that child, for the state to take a child and consider them deprived or terminate parental rights. The fact that Mr. Dyer has invoked his constitutional rights against being compelled to witness against himself by completing a service plan that requires him to admit to child molestation cannot be used against him. DHS, also known as CPS, has made it very clear that Amanda completing a service plan alone would not be satisfactory. Beyond these facts, the state has no right to force a citizen to do any type of service plan. unless they can prove some reason that it is legally warranted. To do so unwarranted is against the very essence of what being a free American is about, against the Constitution, and against Cicero's natural law, which the Constitution is based on. And then I just went over with some motivations that the state would have to file false depravity reports. Alright. I'll go over some of the law stuff. Once again, it's going to be dry, so if you want to fast forward past this and go to something a little more exciting that I'll get into here in a little bit, by all means, please do. Alright. This is Oklahoma State Statutes Title 10 Alpha, Children and Juvenile Codes, Article 2, Section 2 TAC 1005. Now this goes into what the state can remove a child from the home for. It says, no order of the court providing for the initial or continued removal of a child alleged or adjudicated delinquent or in need of supervision from the child's home shall be entered unless the court finds that one of these following things happens. They have to do a determination as to whether or not reasonable efforts have been made to prevent the need for the removal of the child. Now, what reasonable efforts did they make? They tried to get me to admit to being a child molester. That's it. And once I refused to do that, they no longer let me stay in the home with her. A determination as to whether or not the absence of effort to prevent the removal of the child of the home is reasonable upon consideration of the family circumstances. Okay, here's what they have to prove before they can take the child from the home. A court of competent jurisdiction has determined that the parent has subjected the child to one of the following aggravated circumstances: abandonment, torture, chronic abuse, sexual abuse, or chronic life-threatening neglect of the child. So they have to determine that the parent has subjected the child to sexual abuse. They already said that this didn't happen. Obviously, murder of another child, involuntary manslaughter, a bunch of other things they go through here. Now, as far as the behavioral health treatment, the class that they wanted me to go to, under Title 10 Alpha, Article 1, Chapter 3, Section 1, TAC 3, TAC 103, it says that no peace officer, employee of the court, employee of the Department of Human Services, or person consenting or not consenting to medical treatment or behavioral health evaluation or treatment in accordance with the provisions of this title shall have any liability, civil or criminal, for such actions. So they can't hold it against you for not going to these health classes for 2 years. Now here's a termination of a parent's rights to a child. They shall not terminate, the court shall not terminate the rights of a parent unless the child has been adjudicated to be deprived either prior to or concurrently with proceeding to terminate the parental's rights. Termination of parental rights is in the best interest of the child. The court may terminate the right of a parent to a child based on the following legal grounds. If you have written consent from the parent to do so, talks about voluntary consent. If you have abandoned your child, if the child is abandoned as an infant, voluntarily placed in physical custody of DHS, Department of Human Services, or there's a finding that the parent has failed to correct the condition which led to the deprived adjudication of the child, and the parent has been given at least 3 months to correct the condition. So this is after they have taken the child, or after they've given you your ultimatums to correct. What mine was to take a class admitting to being a child molester. Okay. Or a finding that the parent has been convicted, here we go, this is number 8, a finding that the parent has been convicted in a court of competent jurisdiction in any state of the following acts: rape or rape by instrumentation, lewd molestation of a child under 16 years of age, or number 9 here, they have failed to protect the child from abuse or neglect that is heinous or shocking. So, I have not been convicted of rape or rape by instrumentation. I have not been convicted of lewd molestation of a child under 16 years of age. And we did not fail to protect I from abuse or neglect that is heinous or shocking. Still, the laws show that they cannot take our child. And I've got all kinds of appeal court decisions where they say that they can't take the child. So this was what I was taking into the courtroom. And I'm going to wrap it up here and continue with the stuff that gets real good on these next videos.